Welcome, everybody. We're so glad you can join us today for this important and timely webinar on the impact of Trump's executive order and COVID-19 on U.S. immigration. I'm Vinita Mazumdar, president of the SABA Foundation, and I'm very happy that you all were able to join us. The SABA Foundation supports community-based organizations in the areas of domestic violence, discrimination, hate crimes, community access to justice, and of course, immigration. So this topic is really at the crux of our mission. We are so happy to have a fantastic lineup of panelists for you to share their knowledge. So with that, and I'll also mention that we're very happy to welcome also Lakshmi Sridharan, who is with SALT, and she's going to speak for a few minutes at the end. So with that, thank you for joining us, and I'll turn it over to the moderator for the panel, Nimita Mani.
Thanks, Vinita. Hi, everybody. Thank you so much for joining us today. As Vinita said, we are very lucky to be joined by some really experienced and knowledgeable panelists. My name is Nimita Mani. I'm pro bono counsel at Morgan, Lewis & Bockius in New York. And our presenters today are Nisha Karnani, who is a partner at Antonini and Cohen Immigration Law Group in Atlanta, and Tejas Shah, who's a partner at Barnes & Thornburg in Chicago. Nisha and Tejas are both experienced immigration practitioners, as I mentioned, and they're going to talk to us about the recent executive order and what that means in light of COVID-19 and U.S. immigration in general. So to start, could you, Nisha and Tejas, could you kind of walk us through what the executive order that was issued in late April says, and does it freeze essentially U.S. immigration?
Sure, I can start. And so essentially the executive order was preceded by a tweet from the president, which mentioned suspending immigration into the US. And so it created a lot of anxiety and tension about what that meant. And then a few days later, there was an executive order that was issued on April 22nd. And it was actually much more limited in scope compared to the tweet of suspending all immigration. So essentially it only applies to people who are outside the US on the day of the order. And it also only applies to folks who are applying for immigrant visas. And what that means are green card applications at the US consulates outside the US. So it does not apply to temporary visa holders. So a lot of folks in our community have temporary work visas, such as an H-1. It doesn't apply to visitors. It doesn't apply to foreign students who are on F-1 visas. It doesn't apply to some green card categories, including investor green cards. So it was a relief to see that it was temporary. So it's just a pause for 60 days for the processing of immigrant visas outside the US. And I'll turn it over to Tejas to explain some more.
Thanks so much, Nisha. So I'll do a little bit of a deep dive into the family-based categories that are more likely to be impacted by this. So as Nisha mentioned, there are specific family-based categories that are going to be exempt from this particular presidential proclamation's suspension. Specifically, minor children of US citizens and the spouses of US citizens are going to be exempt and can continue to receive their immigrant visas through consulates as they normally would have, notwithstanding the suspension. And now another important aspect of that to understand is that the suspension applies specifically to immigrant visas, which under immigration law has a very specific meaning. It refers to individuals who are applying to get their green cards through US consulates. That's opposed to somebody who's applying for adjustment of status. An adjustment of status refers to somebody who's already in the United States and is applying to receive a green card through an application to US Citizenship and Immigration Services. Individuals who are applying for adjustment of status are specifically exempted from the terms of the suspension or the proclamation. whereas those who are applying for immigrant visas are subject to it, with the exception of those individuals who are considered immediate relatives that I just described. And as a reminder, those individuals would be the spouses and minor children of US citizens. Now, what we commonly see is that there are several categories of family-based immigration that occur through the consulates. And that's often because the beneficiaries of those petitions are often living overseas and don't have an opportunity to adjust their status. So for example, a US citizen may be somebody who's naturalized that then decides to sponsor their adult parents. Those adult parents would typically be applying for their green cards through the consulate, through the immigrant visa process. Those would be individuals who could be impacted by this suspension. The preference categories, which refers to preference categories 1 through 4, that includes adult married and unmarried children of US citizens, meaning anyone over the age of 21, the spouses and children of legal permanent residents, whether they're under 21 or if they're over 21, so long as they're unmarried, and the siblings of US citizens. These are often categories that we see applying for green cards through the immigrant visa process, and they would be impacted by this proclamation, unfortunately. One of the concerns that we have about the impact of the proclamation, even if it doesn't stay in effect for an extended period of time, is the possibility that certain children could age out. Specifically under immigration law, to fit into certain categories, you have to be considered a minor child, meaning that you have to be under the age of 21. And your age for the purpose of immigration law is determined by a law called the Child Status Protection Act, or CSPA. And if you don't receive your green card within a certain time period of when you become eligible to receive your green card, you may age out under the CSPA and then no longer be eligible in that particular preference category. So there is ongoing litigation over this issue. It's part of a lawsuit that's been filed in the Federal District Court for the District of Oregon in Portland. This lawsuit had been started several months ago when the president had issued a health insurance proclamation, basically a requirement that all individuals seeking to immigrate to the United States must possess health insurance. And so while it's possible that we may see other lawsuits challenging this proclamation in the coming days and weeks, so far it seems as though legal action against this proclamation has focused primarily on those individuals who are at risk of aging out.
One thing I would add is the other folks who it does not apply to are folks who have something called TPS, which is temporary protective status. Some members of the South Asian community from Nepal do have TPS, and it doesn't apply to DACA recipients. It does not apply to U visa applicants or recipients. It doesn't apply to T visas, and most VAWA cases are processed in the US. VAWA is the Violence Against Women Act petitions, so it should not affect those folks either. The other thing that's sort of interesting about this is that it is a 60-day pause for now. It does mention that there could be extensions, but the practical effect of it almost seems minimal because the consulates have been closed anyway. So the 60-day pause almost seems like a non-effective measure of doing anything, because, or it would do the same thing as the consulate closures. So that's something to note. The other thing that it does mention is that even though temporary visa holders are not affected, that they are, Department of Labor and Department of Homeland Security are to be consulted in a certain number of days to see if any future impact or changes to the non-immigrant programs are needed. And so, you know, we do have some concern that there could be things in the pipeline that may have a negative effect on our community members. So we definitely need to watch out for that. We don't know what that is. A lot of the programs that seem to have a target on its back, especially in times where unemployment is high, are the H-1B program. So that might be something where we might anticipate changes, but we don't really know specifics at this time. So that's just something to keep in mind, to you know, be on the lookout for extensions or changes. If you guys recall, there was a travel ban or a Muslim ban earlier in the Trump administration, and that was extended and had different versions. So might not be, 60 days might not be the end.
Yeah, I tend to be skeptical of anything that this administration labels temporary for that reason. So I'm not, unfortunately, very optimistic that we're going to see this change 60 days from the date of the proclamation.
So, and I should have mentioned at the outset, if any of the attendees have questions, feel free to put those into the chat function or the Q&A function, and we'll do our best to address them as we go through this webinar. Nisha, Tejas, so does the effect of the order essentially mean that USCIS is not processing cases anymore, or how does that stand?
So no, Namita, it does not mean that USCIS has stopped processing cases. USCIS continues to process cases, including petitions that might be filed for individuals who would be impacted by this particular suspension. I think a good analogy to think of, and actually a client suggested this to me today when I was speaking with him, is that this is almost like a traffic light. The suspension, you can think of it as a traffic light that prevents you from sort of moving forward in the very last step of the process, but it does not mean that you can't take the preparatory steps to move a process forward. So, for example, if we have listeners who are interested in sponsoring their elderly parents for green cards, maybe because they want to be able to have their parents move to the US and live with them, you should know that that process is likely to take a minimum of a calendar year, given all the intermediate steps that are involved, the filing of an I-130, the 6 or 7 months or longer it's going to take to be processed, and then dealing with the National Visa Center after that. So I don't view the suspension as preventing that individual from taking those steps and sort of moving that process forward as far as it can go. Really what the pause does is that it prevents the issuance of an immigrant visa at the very last step. Now, there obviously are many other types of applications that are not impacted by this suspension, as Nisha was outlining, and those also continue to be processed and adjudicated in a normal manner. With the note that premium processing is not available, that's an accelerated form of processing that's available for certain types of business visas. That's been temporarily suspended by USCIS in light of COVID-19. And of course, interviews and citizenship interviews, green card interviews have all been suspended until early June to ensure social distancing. But the service centers that handle applications continue to operate, as far as we can tell, as close to normal as possible.
So for people who have some sort of application that requires an interview, has the deadline is early June, you said, do you have a feeling that that'll be extended, or is it hard to say?
I think it's hard to tell at this point. And part of the reason for that is because there's so much local variation in, what different cities and states are doing about reopening. In a place like Atlanta that, seems to be, at least from a governmental policy standpoint, moving back very close to normal pretty quickly, it would be hard to see USCIS in, the Atlanta office making the decision to continue postponing interviews. But Nisha's going to know more about that than I would. In a place like Chicago, where we have a shelter-in-place order through the end of May, and it's unclear whether it will be extended going forward into June, it's possible that we might see some local variations in how this sort of suspension, what USCIS decides to do on a local case-by-case basis.
The only thing I would add is that there's some immigration often has in-person fingerprint appointments, which have also been suspended. And I have noticed that immigration has been reusing prior prints and waiving the fingerprint appointment for that. So I've actually seen some applications, I don't know if you've seen this, Tejas, I've seen some applications actually speed up, which is a little strange. But some cases require an in-person interview. So marriage interviews, for example, immigration had started interviewing all employment-based green cards as well. We're not sure. I haven't seen anybody get waived for an interview, but we're wondering if that might happen. Sometimes if you sponsor your parent or a child, sometimes those interviews in the past have been waived. So we're wondering, with the big bubble of applications of folks who need to be interviewed, if there might be some waivers down the line. I'm seeing some of my cases go faster, as I mentioned. Some of them, I have noticed the VAWA unit, I think they might have less staff. So I've noticed that I'm getting a little bit of a slower response. I know some of our foundation grantees are on the line, and I have noticed that communication with the VAWA unit takes a little bit longer, but I know that they're still operating. The other thing to note is, as far as people can still check the status of their cases online, you can still call the 800 number for immigration to get information. Those sorts of processes are still happening. So I noticed that there was a perception that immigration is frozen or immigration is closed. That's definitely not the case. It's more the in-person services. They haven't in Atlanta announced for sure if we're going to have USCIS appointments here, because as you guys may know, Georgia is one of the most aggressive states in removing some of the social distancing. But we haven't seen yet how they're going to do it. Usually immigration is full of people. So I'm just thinking this process is going to be slow unless they start exempting people from in-person interviews.
Yeah, and I would just add to what Nisha said that, one important point to bear in mind for people who are in the citizenship process is that until USCIS decides to resume in-person activities, somebody who may have passed their naturalization interview would technically still not be considered a citizen, because you actually have to take the oath. And that's probably going to be one of the last things that's going to change, because unless they significantly reduce the size of those oath ceremonies, there's very little social distancing that happens there. We have a lot of community members that are often very eager to travel once they become citizens and go abroad. It's very, very important for them to bear in mind that you're not, it's not over until the fat lady sings, so to speak, and in this case, you really need to take the oath of citizenship in order to be considered a citizen. And I would also add briefly that, if you are in the midst of some sort of immigration application, make sure that you're paying attention to deadlines. Certain deadlines have been extended by USCIS, based on the date that, let's say, a request for evidence might have been issued, but it's not a blanket, extension. It doesn't go anywhere near as far as I think they could have gone. They haven't made the decision to extend deadlines that occurred between March 1st and May 1st. They only made the decision to extend deadlines for requests that were issued between those dates. And so I think it's just important for people to make sure that they're, either complying or making sure that they get advice on whether a particular deadline has been extended versus simply assuming that something is not due on the date listed by immigration. As Nisha would know, dealing with an application that's been denied because you quote unquote abandoned it is very difficult and frankly, sort of almost like shooting yourself in the foot, and something that we certainly want people to avoid doing.
That's very helpful information. Nisha, you mentioned that some things are actually moving a little faster, some are a little slower. Has USCIS stopped premium processing of applications?
Yes, so there is a process that you can pay an extra $1,440 to immigration to get a quicker answer. It's not every type of case. It's usually just select business immigration cases. A lot of our community members who are on H-1B visas are very reliant on this, because the non-expedited process takes a long time. And so a lot of folks in our community are worried about this, because that means it'll take a long time to know about whether their H-1B extension, for example, is approved. And the reason this is an extremely stressful moment is because immigration has also been denying H-1B extensions, even for people who've had approvals for many, many years. All of a sudden in this administration, questioning things that had been approved a long time ago. And so folks in our community know this. And so a lot of times they'll use the premium processing to get a quick answer. And so you kind of know what to expect. So immigration has suspended that for now. I do expect that they probably will resume it because I think it's a good source of funding for immigration, but we don't know when. So I did notice though that some of my H-1B extensions were again coming back in a matter of a few weeks, several weeks, rather than several months. I don't know if that will last or if it's just dumb luck, but so that's good. The other thing to note is the last time that immigration suspended premium processing, they did mention that they would be more generous with expedite requests. But with an expedite request, you do have to have a good faith reason to jump ahead of the line. So, and have documentation of that. But I hope that what I'm seeing is not dumb luck, and there are some extensions and decisions that are coming faster. It may be because immigration is likely to get a big bubble of H-1B lottery filings soon, and so they may just be trying to clear the deck for those. It may be because some immigration officers are working from home and you can do an H-1B from home perhaps easier. I'm not sure the reason. So we are seeing that premium processing the lack of it is causing a lot of stress for folks because they have to wait longer to know what's going on in your case. The one thing I will tell you is about premium processing is I hate it. I think you pay more money for worse service. What I find is you almost always get a request for documents. Many of times they were already in the package. So don't sweat it too much about premium processing being gone. I always find that the more complex and nuanced cases, I can send regular processing sometimes without a request for more documents. So I do like the regular processing, but I understand the desire for folks to know quickly, sometimes for travel and other reasons. Maybe now also because folks are seeing layoffs and furloughs that, having extended decisions does create a lot more stress. But long story short, we think that premium processing will likely come back, if not just because of the financial incentive immigration probably has to reinstitute it.
You mentioned the financial situation, and there are probably many people who are connected to some of our grantee organizations or other attendees who are on the line today who may be in a situation where they're on a work visa and they lost their job. What should they be doing and thinking about if they're in that situation?
So it's really an unfortunate situation with a lot of work visas is that there's typically only going to be a 60-day grace period after your last day of employment. And so the 60 days does allow you to try to change employers, but that frankly is very difficult when most places have hiring freezes. So if you're not able to find a new employer, another option is to change your status to a visitor, for example, to take more time to look for jobs. You cannot work when you're on a visitor visa, but you are allowed to look for jobs and interview for jobs. You may need to just have time to settle affairs and likewise. So there is an option. There's a 60-day grace period. You can file to change your status or change your employer in that 60-day period. I have noticed that because COVID-19 is a unique situation, we have had some folks be able to ask for leave should not be to avoid a layoff, but asking for leave if you need to care for your children because they're out of school, or if you need to ask for leave for COVID-19 related illness for yourself or your family member. Those types of leaves do not require the employer to pay the wage that's listed on your application. So I do have some folks who are taking advantage of giving a little breathing room to employers who are having a hard time and employees. But unfortunately, you can't go on unpaid leave to avoid a layoff specifically. So it's really a really difficult situation for, again, I mentioned a lot of our South Asian community members are on H-1B visas or L-1 visas, and they're tied to their employment. So it can be difficult. And even if they wanted to leave at the moment, you can't get a flight very easily to go. So Another thing I should mention is immigration has mentioned that they will be flexible if there's a gap in status from when you fall out of status and when you try to change or extend your status. There's always been a regulation that allowed for that, but immigration specifically mentioned that they would be using that. So if you, for example, get a denial and you fall out of status because of that denial and you think you need to change to visitor status to get more time to be able to safely figure out what to do, then that's a possibility. So immigration has said they would do that, but you have to remember you're going to need to document anything to show why your delay was reasonable and why your particular circumstances. But that is something that immigration has mentioned that they will use that authority. So that's something that gives us a little peace of mind. The main thing I would suggest is if I was in that situation, just to try and contact an attorney that doesn't represent your employer right away, because then you can talk to them about your options and what you can do, any eligibility that you may have other than the extension or change of status. You can also ask them, because a lot of folks who are in this situation have pending green card applications at various stages. So you may be able to speak to your own immigration attorney about any special requests that you have. For example, you may be able to ask that the employer not withdraw an I-140, or you may be able to ask, you know, for some additional time off to, you know, settle affairs. Sometimes people will get a severance anyway. So those are things that you should talk to. And remember, you don't want to talk to the attorney who's representing your employer, because they represent the employer and they cannot keep confidential anything that you speak to them about. So you want to find your own immigration attorney, and most will just charge a consultation fee of anywhere between $100 and $300. Immigration attorneys are open. They are, a lot of them, working remotely, but that's what I would do if I'm in that situation. The other thing is want to look at your state benefits to see if you may qualify for unemployment, because it's a state-by-state determination if somebody on a H-1B or L-1, for example, is eligible for unemployment. And a lot of states they are. So that's something that you can look into. And we may talk a little bit later about, you know, how that may or may not impact immigration, but those are the things that I would do if I'm in that situation.
Yeah, and if I could just add one brief point to what Nisha said, I think that don't underestimate the importance also of being able to come up with some sort of creative solution around your final end date with your employer. You know, for individuals who are on H-1B visas, that 60-day grace period is key, and the 60-day grace period is typically going to start, you know, the day after your status terminates, which is the date that your employment ends. Now, as long as, you know, you're able to work with your employer and perhaps treat, you know, any severance amounts that they might pay you if they're terminating your employment, and treat those as days of employment, that can sort of extend out your last date of employment, which could then, you know, extend out the 60-day period as well. Those are all little steps that can sort of, you know, give you a little bit of breathing room, you know, where every day matters. Because remember, again, if you find a new position during that 60-day period, and this is specific to individuals on H-1Bs, you can then transition into working in that new position as long as that application gets filed anytime during that 60-day period. So, you know, communication is helpful, particularly because what I'm finding in my work around these issues is that a lot of employers really don't want to necessarily terminate those H-1B workers, but they're stuck between a rock and a hard place because the agencies don't really give them a whole lot of room in between. There's no unpaid leave, you know, for economic reasons for H-1B workers. And so they're often looking at an alternative where either they have to terminate employment or, you know, continue to pay the individual on the same terms that were listed on that H-1B application.
You had mentioned that immigration had said that they were open to people in this situation changing from, you know, the work visa to a visitor visa or something like that if necessary. Is that a new provision? Is that something new that you're seeing immigration do? Or is that
No, actually, That's been around for a long time. We have helped folks who were dealing with layoffs, or sometimes people transition to student visas. But at this time, if you're financially, in a hard place, it's hard to pay international student fees and change status. But this is something that's been around for a long time, changing status. A lot of times people would end up leaving anyway, and so they didn't use this as much.
Okay.
But if you had asked me pre-COVID, most people who left jobs could easily find another employer to switch to who are in this situation. And now it's very difficult because of hiring freezes and things like that. And so I think some people are using that to just ride things out, see what happens. We can ask for 6 months. So we can ask for a 6-month extension. And as long as you file it when you're in status, you're allowed to stay here while you're waiting on that decision. So it does give a little breathing room to folks, especially people who've been here for a long time, and it's very hard to uproot for being here for so long. I will mention that a lot of folks in our community who are on different work visas have filed for green cards, but because there's a quota system based on country of birth for our green card system, they've been here for a very, very long time and waiting for their green cards in very long queues. And it's really kind of heartbreaking, because if they had, had a similar wait time to other countries, they would have received their green card, and then they wouldn't have to uproot their whole family, with US citizen children who are in middle school, high school, to leave if the system was set up in a better way. So the folks being affected are not just recent immigrants, but they're people whose, roots are pretty deep in the US. So it's a very challenging situation, but what we're trying to do is just deal with it in the moment that we're in. So the tool of trying to get more time to figure out what to do, talk to your employer, a separate attorney, and then talk to your employer, try to come up with a strategy. And I will echo what Tejas is saying. I find employers are really trying to do everything they can, but sometimes they're just financially in a really hard place. And it seems like it would be so much easier if there could just be unpaid leave, but the system's just not set up that way, unfortunately.
What about people that are waiting for a work permit? Should they expect delays?
Similar to what Nisha said, I'm seeing counterintuitively faster decisions on a lot of applications over the last month, which I don't know why that is the case, but they've been coming through. I don't know so much about work permits, whether those are coming through more quickly. I haven't seen that happen. Nisha, I don't know if you've had a different experience with your client.
Some are quick, and then some were just waiting game to see. The folks who have been fingerprinted, I think, will probably come through the same or quicker processing time. I'm a little worried about those folks who've never been fingerprinted or 10 printed, because then they probably have to wait for immigration to start in-person appointments, which will probably create a backlog. My guess is maybe what's happening is the resources that they've allocated to in-person appointments, they can actually work on other parts of processing the case. So the short answer is we don't know. Some of them are coming the same or quicker. There used to be a rule that immigration had to process your work permit in 90 days, but this administration got rid of that, and we were seeing 4 to 6 month processing time for work permits. So just be aware, though, that some work permits, as long as you file on time, will give you an automatic extension of 180 days on your work authorization. So you can look at your receipt notice and check the code that you have with the USCIS website, which is uscis.gov. And that is a good source of information.
And if you do find yourself in a position where you are, waiting for your work permit to come through, you're not in a category like Nisha mentioned where you would be automatically authorized to continue working. Remember that one of the tools you can use is your congressional representative's office, either whoever your local congressional rep is, or one of the 2 U.S. senators for your state. USCIS does allow for the quote unquote expediting of an employment authorization card when you can show economic loss. it's not economic loss to you as an individual, but an economic loss to your employer. You know, particularly if you're working in some sort of healthcare focused field, given how essential that sort of work is right now, you'd have a very good argument to expedite that employment authorization card. And so, you know, you want to call up your congressional representative. Almost all representatives have immigration liaisons. They've been very, very busy for the last 3 years, as you can imagine, with the current administration. But they know how to do this stuff, and they'll let you know what it is that they need. You know, work with your employer to construct some sort of explanation for why it needs to be expedited. And that's just a tool that you should be aware of to accelerate things.
Good to know. What if you're here on a tourist visa or a visitor visa, and for, you know, you can't travel back to your home yet? Is there some flexibility around extending that deadline if your visa is set to expire?
Yes, you can file a form I-539, which is available on the USCIS website. And that's basically an extension of your visitor status. And immigration is seeing a lot of those applications, and we're helping a lot of folks with those too. And basically, you want to make sure you try to file it before your status in the US expires. And your status in the US is not your visa expiration, it's the stamp that was put in your passport. And then there's an electronic version of that. There's something called the I-94. So when you come into the US as a visitor, they stamp your passport, and then they put the date that you have to leave by for that trip. So that's the date that you can stay in the US. And you always want to double check that with the online version. And if you just Google the words I-94, you'll be able to go log into the CBP website, and you enter in your passport, your name, and you can retrieve your electronic I-94. And I recommend everybody always double check that. Sometimes you'll notice that they stamp you and don't write anything, so you need to double check the online I-94. So you can extend your tourist visa, your tourist status in the US. You want to file it with immigration before the status expires, and the most that you can ask for is 6 months. But there may be, depending on what goes on with COVID-19, there may be reasons that you may be able to extend it longer. Again, while you're waiting for your extension, as long as you filed it on time, and as long as you're maintaining your status, meaning, you know, not working when you're not supposed to be working and things like that, then you can stay here while you wait for a decision. So you can ask for 6 months, and what happens a lot of times is it takes them about 5.5 months to determine whether you can stay, and you've got, like, you know, a few weeks left. But it's very important to do that if you cannot travel, because that way you can show that you maintained your status and you did everything you were supposed to do. With COVID-19, it's probably self-explanatory why you can't travel, but it's good to include information on where you'll stay. You want to explain how you're going to support yourself, so that immigration knows that you're not going to work when you're not supposed to work as a visitor. So you can show that by proof of and any savings that you have. If you're staying with family, they can write a letter saying that you're staying with them, and, you know, so that they know that you're not going to work again. But those applications are getting filed a lot at the moment. We have a lot of folks where their parents are visiting. It's not safe for them to travel. So sometimes we're suggesting people include a letter from their doctor if it's easy to get it, but I don't think it's really necessary to document through a doctor letter. I think the main thing is just to make sure you get your application in on time. Sometimes folks use an attorney, sometimes they don't. If you don't use an attorney, you just go and follow the website instructions very, very carefully on where to file it, what form to use. I would always recommend using an attorney if you can afford one, but I know that it's not within everybody's reach. So you, again, go to the USCIS website. The forms are always free. So if you go to a website that is saying that you need to pay money for forms, that's not the appropriate website. And then what you will do is just make sure you look and double check your instructions and you filled everything out correctly.
That's very helpful. You probably haven't seen a lot of extensions come through yet, since we're fairly early, but prior to the current crisis, were extensions, that applications that were submitted properly, most often granted, or if not, what are some of the reasons you see for denials?
I haven't seen any problems with folks getting extensions. Again, usually they have to just be timely filed. Sometimes immigration will ask, in the past, pre-COVID, they would ask for a plane ticket, return plane ticket. Sometimes they would ask for more financial information to show that you won't work. But in the past, I haven't seen an issue. I don't think immigration will be mean-spirited about this particular extension. And again, there is, if you look at your passport and you notice, uh-oh, the stamp expired and I didn't realize it, there may still be a way to do an extension based on the regulation we discussed earlier, which gives you a little bit of forgiveness for small gaps. So I think people are in good shape as long as they follow the instructions on the form.
Yeah, the one thing that's a little different also aside from COVID about the current situation compared to an extension that somebody might have filed last year is the new public charge requirement. You know, if you've ever filed the form before and you look at the form now, you'll notice that it's a little bit different because there's a series of questions there about whether, you know, you've taken any government benefits or you're certified to receive public benefits. And the one concern I have about, you know, filing these extension requests right now, given the health circumstances, is making sure you can show that the individual who's seeking an extension has the capacity to, you know, some sort of, they have health insurance or they have the ability to take care of themselves from a health standpoint. Because I am concerned with this administration and the way, you know, they've tended to operate, that they're going to use this as an opportunity potentially to deny applications from individuals who they think may become primarily dependent on government-sponsored sources for healthcare. So, you know, my advice and recommendation would be, in addition to everything that Nisha just described, make sure you also can document a plan for how that visitor is, you know, what their health coverage is going to look like. Typically, what I've found in our community is that, you know, when people come here on tourist visas, they've already made arrangements for something like that. Maybe they've purchased temporary insurance. And my recommendation would be that you just purchase an extension of that temporary insurance if you can afford it. If you can't, you know, then you may have to look at some other alternatives, but you know, just another issue to be aware of.
You touched on something that I know we all wanted to get into. You mentioned the public charge rules that this administration issued. How does that play into, say, somebody who's now receiving unemployment benefits because they lost their job because of the pandemic, or other public health benefits that you mentioned? Is this going to affect their immigration status or their case, depending on where they are in their immigration journey?
Yeah, so great question. And a lot of the questions that we're receiving right now about, you know, that trigger the public charge analysis include the rebate or stimulus payments that individuals are entitled to receive under the CARES Act, expanded unemployment benefits under the CARES Act, and also medical care and medical treatment that they might receive, you know, if they or a family member have COVID-19. And the good news is that, you know, pretty much in our analysis, pretty much all of those benefits are not relevant to the public charge analysis. In other words, they don't trigger public charge considerations. You know, the tax rebate is really sort of akin to a tax credit and not a means tested public benefit. So that's not going to be relevant to the public charge analysis. Unemployment benefits are not the type of criteria, not the type of benefit that would be also considered a public charge under, you know, the expanded public charge guidance. And then third, with regard to medical care, we've seen some guidance from DHS stating that medical treatment related to COVID-19 will not be sort of incorporated into the public charge analysis because what they want to do is they want to avoid creating a chilling effect for individuals that would prevent them from, you know, receiving treatment that they really should get, not only for themselves, but from a broader public health standpoint for the entire community. Now, that doesn't negate the other expanded criteria that the administration incorporated into the public charge analysis. Those are still going to be issues that, if you're receiving one of those benefits, you still need to be aware of the potential impact that could have on your immigration status. But really, these three programs that I just outlined are the ones that we see most commonly arise in the context of the public charge analysis related to COVID-19. And good news, the silver lining there is that I don't view any of those as being implicating public charge considerations.
One thing I would add is that so the public charge is basically, the rules that they're very new, so we haven't seen the impact of them at the moment. I think we're just starting to file this new form with the green card applications and some other non-immigrant applications. I would just like to point out that the public charge rules do not apply to VAWA cases, so the Violence Against Women Act cases. They don't apply to the U visa cases, so just keep that in mind. The other thing I should mention is that even benefits like unemployment that should not be considered for public charge, they're on the application. Immigration asks you to disclose a lot of benefits that are not a basis to deny for public charge. And it's really important that you are accurate and honest in your application, because hiding the use of a benefit, even if it doesn't affect you, could be a problem for your green card case. So it's really important that when you speak to the attorney preparing your application, that you give them all the information, because I really don't think, someone using unemployment benefits is going to be a problem, but I can see immigration, if they found out, maybe unlikely, but I can see immigration giving people a hard time for not putting certain information accurately on the application. Maybe that's why they're asking so much, I don't know. So the application, it's called the I-944. That's the new application relating to self-sufficiency for the immigrant applicant. And it's very new, it's very detailed and extensive. It's really important that you think about each question and answer it correctly, because I can see folks getting problems for not filling it out properly. The other thing, we kind of touched on the stimulus money a little bit, so thankfully that's not going to be something that's a negative in your immigration case. One thing I wanted to point out is not everybody in our community are going to get the stimulus payments, because they are only going to go to folks who have social security numbers on all the folks on the tax return. So if you're someone who's an H-4 visa holder, that's the spouse of an H-1B, if you don't have work authorization, and not all H-4s do, then you're not going to have a social. So you will have a tax return with somebody, a spouse that does not have a social, so you may not get a stimulus check. And a lot of folks are mixed status families. For example, if you're married to someone undocumented or someone who doesn't have a social for various reasons, then you may not get the stimulus money. So there's a lot of folks who have social security numbers for various types of immigration status. Immigration is very, very complicated as far as determining types of status. To give you an example, being unlawfully present under the immigration law is different from being out of status. And so it's not simple, but I guess my main point is to explain to people that not everybody in our community was included in the stimulus, the CARES Act and the stimulus money. So another question I'm getting is getting the stimulus money going to hurt their green card case? And the answer is no, it's not going to hurt your green card case. Don't worry. I've had people who have tried to ask me how to give the money back because they were worried about how it would impact their case. So don't worry, it's not going to hurt your case if you got that money.
That's very good to know. What if, just another practical question, what if somebody is a legal permanent resident, green card holder, but they are currently outside of the US and for whatever reason can't travel back, it's not safe for them? I understand that there are some limitations around how long they can be outside of the US. And so what are some of the considerations they need to be thinking about, and what steps should they take if they can't come home?
So I think one of the key questions or key issues with anyone who I guess we should back up by pointing out that if you're a permanent resident, the idea with you being a permanent resident is that the U.S. is your domicile, that you intend to make the U.S. your permanent home. It doesn't mean that you can't have ties to a foreign country, but really the idea is that the U.S. is your primary home. And under immigration law, when you have an absence of 6 months or longer from the United States as a permanent resident, if you don't have something called a reentry permit or a returning resident visa, which is referred to as an SB1 under immigration law, that can create a rebuttable presumption that you've abandoned your U.S. home, that you've abandoned your permanent residence. And that presumption gets heightened even further if you've been gone for a year or more. And so I'm sure Nisha is saying this too. We are, talking to folks who say, my parents were planning on coming back in April, but flights from India have been suspended, or they're in Pakistan and I just don't feel comfortable with them getting on an international plane right now. And so for me, the starting point for that conversation is to make sure that, okay, you can document the fact that your parents have ties to the US. We can show that they were there on a temporary visit. They have a bank account or a residence in the US. They have things as simple as library cards or state IDs to show that, they're really maintaining a permanent home here. And similar to the discretion issues that Nisha was describing with regard to immigration filings, I think we're going to see, I would like to believe that we will see similar discretion from CBP, Customs and Border Protection, at the airports when you have individuals like this returning after absences of longer than 6 months, or in some instances, maybe longer than a year, where, it's going to be common knowledge that COVID-19 was an issue all over the world and flights were severely impacted. Certain countries were not allowing outbound flights. And so, to me, the key consideration there is, making sure when you are eventually able to return to the US, you document the fact that you had some ties to the US. You also consider, based on your individual circumstances, how long you were absent, whether it would be more appropriate to actually apply for one of these returning resident visas at a US consulate overseas before you return to the US. I'm trying to tell clients right now not to panic too much if someone's going to be gone for longer than 6 months, because, when it comes to a choice between public health and immigration status, that's a little bit of a Hobson's alternative, and you really should be able to do what you need to do to take care of yourself under the circumstances.
What about people who are in the US and maybe have sponsored a family member, but then they've lost their job? How will that affect their financial sponsorship?
Yeah, so that's a really good question, and a common one that we're getting a lot. So if they've already filed their case, immigration may not collect updated information unless there's an interview, and even then there may not be a collection of updated employment information. But assuming that there is at some point, or you're about to file, what we're telling folks is to just document any COVID-19 related nature of the job loss. So for example, if there is a separation notice, if they can mention that it's COVID-19 related. The folks that, sometimes you can get a joint sponsor, a joint financial sponsor who is a permanent resident or US citizen who can add their financial sponsorship. What I'm also telling folks is just to, if it's, keep looking for work and keep staying useful. So I think there's two sides of it. One is if you're financially sponsoring somebody, and one is that you're the immigrant beneficiary. Both of you now have to, your finances and your ability to earn money is going to be viewed by immigration in processing your case. And so what we are telling folks is if you can't control the fact that you've lost your job, but what you can control are, maybe gaining skills while you're in between jobs, trying to document that this COVID-19 related, trying to find a co-sponsor if possible. There are other ways to count income, for example, sometimes assets, or counting other folks in the household and what they make. So just realize that it might have an effect. Talk to the attorney who is helping you or has filed the case to see what may need to be done. For example, usually immigration will ask for the last tax return. Does it make sense to delay, the subsequent tax filing? Or there's a lot of strategy issues that people can use. So the other thing I would mention to folks is, if you don't have an attorney helping you on your case and you're doing it on your own, there's no harm in doing a consultation to write down all your questions that you have for attorneys, because it's better to just have all the information you can on your specific case. There's a lot of great information on the internet, and there's also a lot of wrong information or stale information. And one small detail in people's case can change everything. So for the folks who are out there and have questions, you can find answers oftentimes, even if you can't afford a retainer for an attorney. Just doing a consultation, you can call them and ask ahead of time, is there going to be, a fee? Is there a time limit? And write down all your questions. You may be able to even find pro bono attorneys to do consultations depending on your state, to figure out what's going on. While a lot of the nonprofits that work on immigration are working from home, a lot of them are still operating. So if you can't afford an attorney, reach out, try to get the guidance for your case, because again, it's one small detail with immigration that can really make a huge difference.
Thank you both so much. I want to make sure we have enough time. I want to be mindful of people's time, and also make sure we have time to hear from Lakshmi Sridharan, who joined us today, who's from SALT. But sort of transitioning into SALT's work, I wanted to ask of all of you, what are you seeing in terms of enforcement? And are enforcement and removal operations still continuing at the same pace? Are they accelerated? What are all of you seeing? And we'd love to hear, Lakshmi, how SALT is stepping in to help in this space.
Thank you so much for having me on this very informative webinar. So at SALT, we're a national racial justice and civil rights organization based in DC. And so we focus on addressing hate violence, immigrant justice, and in issues of civil rights surveillance and enforcement, like you mentioned. And so I think historically, and now in the context of COVID-19, our work on immigrant justice in particular has increasingly focused on the most marginalized populations within the South Asian community. And so many of those, were covered in the webinar today, but in particular, we've been tracking the rapid uptick in South Asians being apprehended at the US-Mexico border. And this is a trend that we've seen, over the last 10 years, but that has really sharply increased in the last 3 years under this administration in particular. So just to give you a couple of data points, in 2008, 77 Indian nationals alone were apprehended by Customs and Border Protection at the US-Mexico border, but that number has jumped to over 10,000 in 2019, and that's just Indians alone. And so we unfortunately don't have the disaggregated data that we should for the South Asian community broadly, but we do know that since 2017, Immigration and Customs Enforcement, or ICE, has detained over 3,000 South Asian migrants. And there's a number of push factors for this migration, I think not the least of which is the condition of religious minorities in India, in particular in the last few years, which is requiring folks increasingly to have to seek asylum. And 2019 was a really difficult year with many detained South Asian migrants being deported back to very dangerous conditions. And many of you, I'm sure, saw the young 6-year-old Sikh child from India who died in the desert outside of Arizona, attempting to reach the US-Mexico border with her mother and other community members. And those are, just a few examples. And so, for SALT as a domestic organization, we're kind of very concerned about the conditions that migrants are facing within detention facilities in the US. And I'm sure folks have also seen, some of the data around the percentages of people who are in detention facilities, who are in the criminal justice system right now and incarcerated, who are facing these very high COVID outbreak levels in these facilities. And so that's something we're seeing in Texas and Louisiana and New Mexico. And, I think that just makes the conditions that they're already facing even more challenging. And one of the things we've been following is that South Asian migrants in detention are often going on prolonged hunger strike to protest the conditions that they're facing in detention, but also to draw attention to their asylum cases, which are often neglected or unheard. And that's because of a lot of, I think, lack of understanding from immigration judges about country conditions in India and across South Asia. But also, they're facing conditions like inadequate or non-existent language access, denial of religious accommodations, really gross medical neglect, solitary confinement as a form of retaliation, and then very inhumane methods of force feeding in the case of hunger strikes. And some of these hunger strikes have lasted over 100 days, and then people are being deported under these conditions back to South Asia. And I think one of the things I really wanted to highlight on this call too was the uncharacteristically high bond amounts that we're also seeing for many South Asian detained migrants. So in the rare case that they're able to be released on bond as they await their asylum case, we're seeing an average bond rate for South Asians being set at $25,000 to $30,000 when it should be really in the $1,500 range. And so over the last year, we've worked really closely with our allies and local immigrant justice partners in El Paso in particular to try to support as many of these asylum cases as possible. And I think what we've been able to do well is to direct a lot of language assistance in many of these cases, to have case documents translated into appropriate South Asian languages, or to have an interpreter on the phone with the lawyer in some of the cases. But I think where we're really challenged as a community is being able to develop, I think, robust legal support down there for these detained migrants. And as you can imagine, in those regions of the country, lawyers and legal organizations are just way over capacity in terms of being able to take on these cases, and often have to go through a very arduous appeal process where they need more legal assistance to be able to complete these cases. And so that's one of the appeals that I'm making on the webinar today, is for folks who have the capacity and the ability to be able to provide that pro bono legal assistance that's needed down there for our community members who are detained. And we're happy to provide more information. I know that's a very complicated process to support asylum cases, and that's something that we're working to hopefully get some type of handbook or manual or some steps in place that could enable those who are interested to be able to provide that kind of legal support down there. And then the second piece is that we are working to create some type of South Asian bond fund for those who are detained and able to be released on bond. And there's one current case right now of an Indian man who's at the Wynn Correctional Facility in Louisiana, who was on prolonged hunger strike and has been set with a bond amount of $30,000 to be released. Unfortunately, his family members are not able to meet that requirement, and so we're working to raise funds for him. And so as an immediate next step for those, again, who have the resources and capacity, we are collecting donations on our website at salt.org for this purpose. And we would be very happy to accept any contributions towards this purpose, and folks are able to send a note that that's what you would like your donation to go towards. And I hope that we can continue working with the SABA Foundation, SABA National, and others to create this support, this legal and financial support for our community members who are the most vulnerable to begin with, and even more so now under these conditions of COVID-19. So thank you.
Thank you, Lakshmi. For everyone joining today, we are going to send out a FAQ document after the webinar that goes over a lot of the information that we talked about, that provides information on how to connect to SALT, to either volunteer for one of these pro bono opportunities to assist migrants all over the country, and especially at the border, who desperately need counsel, and also to contribute to the bond fund. So you'll have a chance to learn more about all of these things. And if there were any questions that came in that we didn't get to address today during today's webinar, we'll be sure to incorporate those into our FAQ. So thank you everybody for joining us today, and thank you especially to Nisha, Tejas, and Lakshmi for informing us about sort of what's going on right now and taking time out of your day to share your expertise.
Thank you, Namta.
Thank you so much.
Thanks, everybody.
Bye.
Take care.